Hi, my name's Kirsty McNulty and I'm a member of the Contentious Trusts and Probate team here at Forbes. Today I'm going to speak about various questions that we get asked on a very regular basis in relation to will disputes and validity challenges in general. So the first question is, what are the grounds for contesting a will? So there are several grounds upon which a will can be contested, which I will go through in a little bit of detail today. So the first being want of due execution of the will. So a will is a very formal legal document which is required to be executed correctly in order for it to be valid, i.e. It has to be signed by the person who's making the will, and that needs to be done in the presence of two witnesses who are both present at the same time. For whatever reason, sometimes this doesn't occur. Sometimes people make homemade wills and they're not aware that they need more than one witness, or they're not aware that the witnesses need to be there together and at the same time, or even in some cases the person hasn't realised that they actually haven't signed the will. So all of those things need to be checked just as a first starting point to ensure that the actual will is valid. So the second ground is if the person who made the will has the sufficient mental capacity to have done so. So again, when making a will document, the law does require that that person has what we call testamentary capacity, meaning they must understand the content of the document and the implications of what they have set out in their will and the impact that this would have on any family members who, i.e., may have been excluded. So grounds for lack of capacity will often be based on if the person has begun to suffer with dementia, if it's an elderly person, if the person has any kind of cognitive difficulties, learning difficulties, or has suffered any kind of serious mental health issues which may have been dominant at the time that they made the will, meaning that they weren't in the correct frame of mind to be able to make that document and fully understand the implications of the same. So the third ground would be undue influence. Now, this is something that is quite often reported on in cases which sometimes make the newspapers, whereby a vulnerable or elderly person can be influenced by a family member or a friend or relative to change the will, and quite often that would be in that person's favour. So things that are reported on from time to time are things like somebody that perhaps helps in the home who has befriended somebody who is vulnerable or elderly, and coerce them in some way to change the will. And the kind of red flags that we would look out for, I guess, in these situations would be if the person took them to a solicitor to change the will, or the fact that there was no rhyme or reason as to why the changes had actually been made to favour that person. So the final ground is knowledge and approval of the will. So the person who has made the will must have been fully read over the will and understood the contents of it. So this can apply occasionally in cases whereby the testator perhaps doesn't read or write very well, or doesn't have a perfect knowledge of English, if it's somebody who lives here from a different country, and a family member may think, well, I don't know how, i.e. my mother or father has understood this will because they didn't speak or read English fluently, and there's nothing in any kind of note or statement to say that this document was actually read over to them or translated. That would be an example of where knowledge and approval of the will could possibly be disputed. So moving on to the next question that we are asked on a general basis is, how do I contest a will? So in order to contest a will, we would need to look at all of the evidence that is available to us in that respect. So this can take the form of a statement from a solicitor who has prepared the said will, which is referred to as a Larkin Nugis statement, and that would be a comprehensive statement detailing the conversation that has taken place with the testator at the time that the will was made, a detailed file note, and any observations that the solicitor has made about how the person presented at the time of giving instructions and also signing their will. It would also include whether anybody else was present with them, and the general mindset that the person was in on the day of the appointment, and detailing the reasons for why they were either making or changing the will. So the other big body of evidence, which is usual for us to have to look at in these types of validity challenges, would be medical records if the person is of the belief that the testator was lacking mental capacity at the time of executing the will. So this can be an onerous task. Medical records are often in large volume, and effectively we would have to review the medical records, often with the assistance of an expert, to pick through the records and see if there is any red flags there, such as the person was perhaps diagnosed with some sort of early onset degenerative mental disease, had been going to the memory clinic, was on any kind of medication that might alter their mindset effectively. So the main body of evidence that we would look at is explained there. We would perhaps take some witness evidence from other people who may have had some knowledge about the will being made, if there was any thought of undue influence or anything like that at the time. So in the course of reviewing all of that evidence, we would then be able to speak with you in much greater detail, take full instructions, and then prepare a full advice upon the legal position before then being able to advise on the potential merits of any claim. If we did think that the claim was likely to be one with good prospects, the next step would be to then prepare a letter of claim to send to the executors and beneficiaries of the estate. So another question that we're often asked is, who can make a claim against an estate under the Inheritance Act? So there are several classes of people, inclusive of spouses and children, and also people who may be financially dependent upon the deceased, who are able to make a claim under the Inheritance Act. Claims under the Inheritance Act are not for a share that you think you should have had from an estate, i.e. if you have 3 siblings and you have been excluded from the will, making a claim under the Inheritance Act is not a claim to say, well, I want my 1/4 share. The purpose of the inheritance known as reasonable financial provision to any claimant. So there are several criteria that such claimants would need to satisfy. One, they would have to demonstrate that they have a financial need and that they have poor financial circumstances, i.e. don't own their own property, don't have any savings, have limited income capacity, and also may have debts and not be able to improve their financial position. Other factors which are important can also be conduct. So estrangement can sometimes make these types of cases difficult. And also if the claimant has any serious physical or mental health issues, which again would impact on their earning potential and thus their financial position. So sometimes we get clients who come who have been left a gift or a portion of the estate, and they're not sure whether they can make a claim under the Inheritance Act due to this for further reasonable financial provision. So that is something that we would review, but that certainly doesn't stop you or eradicate you from a person who may make a claim. I had dealt with a client who was left a gift of £5,000 from an estate that was worth a substantial amount, and we pursued a claim under the Inheritance Act because that wasn't enough to provide him with reasonable financial provision. So again, with the Inheritance Act, we would need to speak with any prospective clients in more detail, review any documentation that they have, and advise on a legal position. We are able to offer several funding options for this type of work, including no win, no fee and deferred fees, as well as privately paid cases. And these can obviously be tailored to the needs of each prospective claimant. So another question we get is, how long do I have to contest a will? So there is no specific time frame on when a person can contest a will, but what we would advise is it's better to do it sooner rather than later. If an estate is administered and then several years later somebody comes and says, actually, I don't think that will was right, or I should have been included, or I think there was another will, it's really, really difficult to obviously then claw those assets or distributed funds back into the estate. So the advice would always be to act as quickly as possible after the death of the testator. Just a little point about Inheritance Act, actually, there is a time limitation on Inheritance Act claims. So a claimant would only have 6 months from the date of the grant of probate to be able to bring a claim. If you don't apply in that time, you may seek permission of the court to be able to bring an out of time claim, but this can be very, very difficult, and you've got to have a really good reason as to why the limitation date has been missed. I.e., if you were to say, well, I just hadn't got around to going to see a solicitor, and but I'm here now, that's not going to cut it, and that would mean that you couldn't bring your claim. So again, in those circumstances, as soon as you think that you might have a claim, the quicker that you can take legal advice, the better, to avoid either being in a really pressurised situation coming up to a limitation date, or even worse, actually missing the limitation date. So the next question is, can the validity of a will be contested after probate has been granted? And in a nutshell, yes, it can. But again, as I've just said, the quicker that it is done, the better, because once probate is granted, that gives the executors the power to begin the administration, the legal power to start dissipating and distributing assets. So another interesting question is, how long does contesting a will take? It's kind of like how long is a piece of string. Every case is different. Some cases settle very, very quickly. Some cases will go all the way to a defended trial. So it is difficult to say. I guess the first gauge is when we would send out a letter of claim. We would see what the response from the opposition was like. Sometimes you get opposition who are willing to engage in negotiations towards settlement. Sometimes you come up against opposition who are going to fight it every step of the way. So in most cases, we would hope that these types of claims would settle through ongoing correspondence, negotiations, and without prejudice offers, as well as mediation appointments. In those circumstances, it could settle within 6 to maybe 12 months. For a case that is defended or a challenge that is defended all the way to a contested trial, you could be looking upwards of 12 months. It would depend, I guess, upon the availability that the court has. At the moment, with us being in the global pandemic, there's massive delays with court listings. And also sometimes evidential issues can cause delays if it's taking a while to obtain some documentation. So it's difficult to say. Each case is, I guess, on its own merits, but a broad brushstroke would probably be between 6 to 18 months. So sometimes we get calls from executors who are a little unsure about what their duties are. One of the questions we've had is, can I contest a will if I am an executor? Again, in a nutshell, yes, you can, but our advice would probably be that you should renounce from your role as an executor, as it can lead to a conflict of interest and make it really difficult for you to deal with a dispute as well as the actual non-contentious aspect of the estate. So if you find yourself in that position, it's definitely worth taking legal advice. So we're asked if you have to go to court to contest a will. I've probably just touched on this a little bit briefly previously. The majority of claims don't proceed to a fully contested trial, and many will just settle on the way through negotiation and mediation as mentioned. However, if it cannot be settled, a claim would have to proceed to the court, because if agreement can't be reached, then unfortunately we have to present all of the evidence to the court and let them decide. So another question is, again, from an executor's perspective, I'm an executor of a contested will, what should I do? And as mentioned, we do get calls from worried executors because quite often executors find themselves with a job that they probably haven't asked for. It's quite an onerous task, and it's probably quite unexpected a lot of the time. And then to boot, if you find that you are dealing with an estate which also has the added element of a dispute, it can be really difficult and challenging for lay individuals to get their head round everything that needs to be done. So our advice would be, if as an executor you receive any kind of letter from any kind of opposition or any disgruntled beneficiary, family member, whoever it may be, you should seek legal advice upon such correspondence. We would usually suggest that you simply reply in the first instance, just to let them know that you are taking your own legal advice and that you will respond to them in person, or your representative will respond to them in due course. So we would then need to speak with you in more detail. We would need to review any documents that you have and any documents that you've received from any beneficiary or opposition as it may be. We would then be able to advise you upon the legal position and, if needed, respond to the other side to be able to try and resolve any issues that are there. So again, as mentioned with the Inheritance Act claims, we do have several funding options available. There is the possibility of no win, no fee. There is the possibility of deferred fees, but obviously we would just need to evaluate the prospects of any case and obviously decide that with any prospective client at the time. So just a word of warning for anybody who is an executor who finds himself in a position where you have had some kind of response from a disgruntled beneficiary or any kind of opposition to the will. It's not something to ignore. If you merrily continue and undertake your duties to administer the estate, should the claim, prospective claim or issue be upheld and you have dissipated that estate and the beneficiaries say, oh, well, sorry, I've spent the money now, you are putting yourself in a position where you could be personally liable. So you've got to be really, really careful, and our advice would always be to just make sure you get legal advice just to protect your own position in that respect. So sometimes we have calls from clients where they're not happy with the way an executor is dealing with an estate. And the question we get asked is, can an executor be removed? So executors do have certain duties that they must adhere to in the role as an executor. If they fail to do so, then the answer in a nutshell is yes, they can be removed. It's not something that's undertaken lightly. They've got to have behaved in such a way that is quite serious. Just if they're just taking a little bit of a long time, or they just haven't provided you with something when they said they would, it's probably not grounds to be able to remove them. But if they are failing to administer the estate in accordance with what a valid will says, or they are taking a ridiculously long amount of time which is causing detriment to the beneficiaries, or any assets, i.e. property that is just sat there unsold because it hasn't been marketed or causing expense to the estate, then they can be removed for being in breach of trust of their duties. So again, if you are a beneficiary or anybody who is upset with the way an executor is dealing with an estate, of course we are able to assist you. Again, we would take all of the relevant information from you and send a letter of claim to the executor in question. In my experience, usually these things are able to be resolved quite quickly, and having received a legal letter, an executor will quite often think crikey and get on board with the job and then keep people updated. Sometimes, however, that's not the case, and it may be that we need to make an application for the executor to be removed and somebody in their stead to deal with the estate. Obviously, this would involve court proceedings, and I guess the threat would always be that we would let them know that we would potentially pursue them for the cost of such application. So, yes, it's advisable to avoid having to make an application to the court, and we would obviously do everything that we could to resolve the issues without the need for this. So finally, the last question is, what is a caveat? So a caveat is a notice that is entered at the probate registry which prevents a grant of probate being issued in somebody's estate. So from a procedural perspective, a solicitor can do this, a layperson can do this. And what it effectively does is when the executors or administrators of an estate go to make the probate application, they will get a little hand to say, sorry, you can't do that. Somebody has lodged a caveat to stop you doing so. This is usually done in validity challenge cases, and the usual reason is to ensure that whoever it is that wants to launch a validity challenge has the sufficient time to get together any evidence, i.e. the medical record statements from solicitors, witness evidence, etc. It is a fee of £20 to lodge a caveat. And it remains in place for 6 months. At that point, you would need to make an application to renew and leave the caveat to continue. Just a brief note about caveats. If the other side want the caveat to be removed, they can enter a warning. And at that point, you would need to set out why you want that caveat to continue, and it's to stop people just putting caveats there when they don't really have any grounds to stop an estate, i.e. somebody who's just not happy with how a will has been left, but they accept that it is a valid will. So it's to protect estates in that respect as well, to effectively stop nuisance caveats being entered. If you refuse to remove it and you don't enter an appearance to a warning, then the probate registry will remove in any event. But this can have implications and cost implications, etc. So again, in terms of validity challenge in general, caveats, we are able to offer advice over the telephone. As mentioned, we have several funding options to be able to assist clients on all of the matters that I've discussed today. So my details will come up on the screen at the end of this video. As mentioned, I'm available on email, I'm available by telephone, and I'm always happy to have a quick discussion over the phone, just to go through the details and possibly offer a brief advice on prospects and whether we can take things forward. Thank you very much for listening today.